So, welcome to the quick revision series of Polity for UPSC Prelims examination 2024. In the last session that I was there with you, we had discussed some of the important conceptual aspects from the examination point of view. Now, in today's class also, we will be taking up for discussion some of the conceptual things. Now, we were discussing basically first of all the political systems, we had discussed democracy, then we had discussed the parliamentary system. Now, another area from which the UPSC is very fond of asking question is another political system, that is the federal system. So, with respect to India, we say that it is a federal system. It is a federal system with strong unitary features. Professor K.C. Ware had termed India as quasi-federal. Termed India as quasi-federal. Then the drafting committee of the constitution, it had held that it is a federal system. So, these are the nomenclatures which are attached to this nature of Indian federalism: quasi-federal, federal system, a federal system with a strong unitary features. Now, from this aspect, some textual question can be asked, conceptual question can be asked in the prelims examination, because political system has been mentioned in our syllabus. So, here what are the essential conditions of a true federation? A written constitution, there should be supremacy of the constitution, then division of powers, rigid constitution, a bicameral legislature, then an independent judiciary. Now, in the prelims examination, the question will be that which one of the following is a feature of a true federation? 1 and 2, 2 and 3, 3 and 4, such questions will be there. And a very tricky thing, I will tell you that what the UPSC can do is that in place of independent judiciary, in the question it can be a committed judiciary. So remember that only these are the aspects which are correct one from the examination point of view. So if it is not independent, if the word committed is mentioned here, then you are not supposed to encircle it, it will be a wrong answer. Independent judiciary will be the correct answer. So these are the essential conditions. So from here one question can be expected in the examination. Now when we talk about the next important topic from the prelims point of view, it can be the preamble. Preamble, basically some statements may be there in the examination from the preamble, and when we talk about the preamble, the first important statement can be, it is not mandatory but customary on the part of a written constitution to have a preamble. To have a preamble. So it is not mandatory, it is customary. Nowhere it has been mentioned that there has to be a preamble of a written constitution. Then the preamble is termed as the soul of the constitution. No doubt, when we talk about the preamble, technically it is the soul of the constitution, but the students sometimes get confused and they encircle that Article 32 is the soul of the constitution. They may also not be wrong here, because Dr. Ambedkar had held that Article 32 of the constitution, that is right to constitutional remedies, is the heart and soul of the constitution. So here, but in the examination we are supposed to encircle the preamble, because the preamble is the soul of the constitution. That is the interpretation of the court also. And the UPSC, in one of the examination earlier, in the PYQs this question was there, and the Supreme Court had held that the soul of the constitution is the preamble, and the UPSC had in its key had also held that this will be the correct answer. So such aspects, it contains the philosophy, it contains the summary of the constitution. Preamble is a topic from where good number of questions are asked in the examination. Another area from where the questions can be asked can be some statements also again, and here some other statements can be that the preamble declares the supremacy of the people, it declares the supremacy of the people of India. You see, in the preamble, the words are "we the people." So, no doubt in the main examination, they may ask you the significance of the preamble, but in the prelims examination, your understanding about the preamble can be asked. So, here the understanding is it declares the supremacy of the people of India. Then, so your keyword here will be, your understanding will be, as it says, "we the people of India." It means that this constitution is not an imposition upon us by an alien power, but it has been enacted by the people of India through their representatives in the Constituent Assembly. That is the logic here. Then, moving forward, another aspect from where the questions are expected in the prelims examination from the preamble is a debate. Is the preamble a part of the constitution? Now here you see that there are two words, there are two aspects related to it. One is the conventional view, and the other one is the modern view. When we analyze the conventional view, means the traditional view, this view was given by the Supreme Court in the R.E. Perubari Union case. Of 1960. The the Supreme Court in this case had held that preamble is not a part of the constitution. The preamble is the key to open the minds of the constitution makers. So, which part of the constitution is the key to open the minds of the constitution makers? The answer will be preamble. So, this was the view, and then the court also said that no doubt the preamble is the key to open the minds of the constitution makers, but it is not enforceable by a court of law. By a court of law. So, such statements will be there in your prelims examination. Then when we talk about the modern view can be termed to be given in the Keshwanand Bharati case. Now, in this case, the Supreme Court had held that the preamble is a part of the Constitution. And why the Supreme Court had held that the preamble is a part of the Constitution? The reason being that the Supreme Court had held that the preamble was adopted in the same manner as the other provisions of the Constitution were adopted. So it means that discussions and debates had taken place for each and every word, then after that the voting, and then the preamble was adopted. So this was the view of the Supreme Court. Then here one more thing that the Supreme Court had said, that the preamble, it is not a source of restriction or prohibition so here the Supreme Court had held that it is not a source of restriction. It is not a source of restriction or prohibition. So these words are the key words from the prelims point of view. In the examination, the UPSC is not going to ask you question based on the name of the case, but which of the following statement is correct. So the correct statement here, if it is not a source of restriction or prohibition. So if you talk about the preamble, it is not imposing restriction on any organ of the government that you are not supposed to do this. So it is not a restriction or prohibition. This will be the correct statement. Not only this, when we talk about the Keshwanand Bharati case, in the Keshwanand Bharati case, the Supreme Court had also held that the preamble basically helps us in understanding the philosophy of the Constitution. So whenever we have got doubt that what exactly the provision of the Constitution says, we can refer to the preamble. So this is the utility of the preamble. Then in the LIC case, the Supreme Court had held that preamble is an integral part of the Constitution. It is an integral part of the Constitution, but it is not directly enforceable in a court of law. So here it is not directly enforceable in a court of law. So you can relate it with some of the provisions, and then basically what you can do is that you can go to the or approach the court of law. Here if you see that such type of statements have been asked in the previous year's questions from the preamble, this aspect. So they may not ask you whether the preamble is a part of the constitution or not, but such statements can be asked in the examination. Now coming to the next aspect, another area from where the questions are asked from the preamble. No doubt it is a very easy area, you need to revise it, that it is from the amendment to the preamble. Or amendment of the preamble. The two things that you need to remember: one, the preamble was amended by the 42nd Amendment Act 1976. Three words were added. You may be knowing it: socialist, secular, and integrity. So these three words. Then another question, another statement can be there, that the Constitution of India or the original Constitution described India as so the original Constitution had described India as sovereign democratic republic. So after this word sovereign, socialist and secular words were added here. So according to the original Constitution, India was a sovereign democratic republic. We need to remember this much. Then coming to the next aspect from where the questions can be expected in the preamble is the understanding of some of the words which are there. Then keywords of the preamble. Sovereignty questions may not be expected in the prelims examination, so we will not be discussing it. You see, from socialism, from socialist, we have got this word socialism. Socialism. And when we analyze this concept of socialism, what are the dimensions of Indian socialism that can be important from the examination point of view? Socialism is state ownership of the means of production and distribution. Then when we say it is state ownership of the means of production and distribution, then another thing that comes in our mind is what is the difference between socialism and communism? Questions can be expected from here also. When we talk about socialism, socialism is a state ownership of the means of production and distribution. There will be a state here, and the means of production and distribution will not be in the hands of the private persons, but from, we can say, in the hands of the state. Then questions we have seen in the PYQs, they have been from communism also. Now, what is the basic difference between socialism and communism? You see, socially, both, we can say, terms are Marxist terms. Socialism is state ownership of the means of production and distribution. You see, the objective of Karl Marx was not socialism. Basically, his objective was to have a society where there will be economic equality. That is why he said that socialism will be a transition period, it is not the end, and there will be established communism gradually. Now, communism is a classless, stateless society. Now, here comes another question from the prelims point of view, that a classless society according to Karl Marx meant. So, a classless society according to Karl Marx meant the prevalence of only one class, that is the workers' class. That is the workers' class. So, in the MCQs, if such questions are there, that which of the following is correct regarding a classless society, and the correct option will be that presence of only one class, that is the workers' class. Then I hope that you may have read the things in detail, only you are doing the revision along with me, that okay, these are the keywords, what are the aspects that we need to remember from the examination point of view, because only 10 days are there for your examination. Then when we talk about this concept of stateless society, here the question can be that which of the following is common to both Mahatma Gandhi and Karl Marx. It is also a PYQ. Then the concept of a stateless society, it is common to both Marx and Gandhiji. No doubt, both had got their different aspects. Marx had talked about a classless society in a different term. Gandhiji, he had talked about the classless society in some different context. But in the examination, basically your basic knowledge will be tested, that whether you have understood Gandhism or not, communism or not. So, Gandhiji was not a communist, but Gandhiji stood for a stateless society. Karl Marx also stood for a stateless society. So, from here such questions can be expected. Then dimensions of Indian socialism. You see, we did not follow exactly what Karl Marx said. We followed the concept of mixed economy. This may not be asked in your examination. And how we deviated from what Karl Marx had said, we did not go for the state ownership of the means of production and distribution. We went for democratic or Fabian socialism. Fabian socialism. Now here comes another question from the examination point of view, that which of the following is the statement is correct. In India we have adopted Fabian socialism. Now what is this concept of Fabian socialism? That is, we want to achieve socialism through democratic means, that is, through the parliamentary laws. So, socialism to be achieved through democratic means, that is through the parliamentary laws. Now from here, what questions can be expected? One, I told you, Fabian socialism, and another question can be reasoning assertion question, that in India we have adopted Fabian socialism, or India has adopted Fabian socialism. India wants to achieve socialism through the parliamentary laws. Both A and R are correct, and R is the correct explanation of A. So here you need to stress on this aspect. Then coming to the third aspect, what is the objective of Indian socialism? For Marx, we had discussed that it was a stateless society where there is economic equality, but for us, that is for India, our objective is to establish a welfare state. To establish a welfare state. So from here the questions can be, important one will be this, the concept of Fabian socialism, you need to understand it. So from socialism such type of questions can be asked in the examination. Now the next term that is there in the preamble, that is from secular, it is secularism. Now coming to this word secularism, secularism is religious neutralism on the part of the state. no state religion. No state religion. Now, here the statements will be there, that which of the statements best describes the nature of Indian secularism. So, it is religious neutralism on the part of the state, it is a Western concept. No state religion, obviously India has got no state religion. If this statement is there, you can encircle it. Then there can be other statements also, that is equal treatment to all the religions. To all the religions. Or we can also say, देखो अलग अलग statements can be there, different statements can be there. Then when we say equal treatment to all the religions, this can be one of the statements. Then another statement can be the state shall honor all the faiths equally. Then there shall be no discrimination among the citizens on the basis of religion. Freedom of religion or irreligion for all. For all. So, such type of statements may be there, that which of the following statements best describes the Indian secularism. So, no state religion, equal treatment to all the religions, the state shall honor all the faiths equally, no discrimination among the citizens on the basis of religion, and freedom of religion or irreligion for all. You will have the freedom to follow any religion. You can be an atheist also. You may not follow any religion also. Then when we talk about Mahatma Gandhi, Gandhi ji talked about that is the Gandhian view, we can say. Was that of Sarva Dharma Sambhav. Sarva Dharma Sambhav, that is coexistence of all the religions. Coexistence of all the religions. So, such type of statements will be there in the examination. Then on the basis of your understanding, there can be another statement that in India we have got the concept of positive secularism. It is not the Western concept of secularism, that is, there stands a separation, the wall of separation between the domain of state and the domain of religion. But in our country, it is equal treatment to all the religions. There is a positive concept of secularism. Then the word democracy we had discussed in detail in the first session that I was there with you. There is what type of questions can be asked in the examination from democracy, so there is no need to repeat it here again. Then republic, there is no need, we all know that what is a republic. The head of the state is an elected one. Now from the second part of the preamble, the questions can be asked related to justice. The factual questions will be there, that the preamble envisages which types of justice. So the preamble envisages social, economic and political justice. Political justice. And there can be question which of the provisions of the Constitution they aim to achieve the end of social justice. So articles 15 and 16, then some of the directive principles of state policies, they aim to achieve the end of social justice. Then economic justice is to be attained through articles 39 clauses B and C. Now such questions will be expected in the prelims examination, that which of the following statement is correct, or which of the articles of the Constitution they aim to achieve the end of economic justice. Articles 39 clauses B and C. Article 39 clause B, when you were preparing for your examination, you may have discussed or you may have read that it holds that the resources, the material resources, to be distributed in such a manner that it should be for the common good. On the other hand, Article 39 clause C, it talks about prevention of concentration of wealth in fewer hands. So these two articles of the Constitution, which are in part 4, they aim to achieve the end of economic justice. Political justice has to be achieved through some of the fundamental rights, and Article 326. Then liberty. Now when we say this liberty, the preamble talks about liberty of thought, expression, belief, faith and worship. When we say the easiest question that can be asked, that which of the liberties has been envisaged by the preamble. So liberty of thought, expression, belief, faith and worship, that is mentioned in our preamble. And then if you go to the level of some difficult level, then the basic understanding of liberty can be asked. So when we talk about liberty, liberty means absence of restraints. It means absence of restraints. Means there can be no restrictions on the freedom of the individuals. Basically, the classical liberals, they were of this view that the state is a necessary evil. Why the state is an evil? Because the state puts restrictions on the freedom of the individual. But why it is necessary? It is necessary to have the regulatory functions, that is maintenance of law and order. So this is the meaning liberty, this is one of the meaning. Liberty means absence of restraints. Not only this, it will also mean that the presence of conditions in which an individual can develop himself. So presence of conditions in which an individual can develop himself, then presence of conditions under which an individual can enjoy his rights So here basically, if we talk about this first one, liberty means absence of restraints. It is freedom from the state. It is freedom from the state, freedom from the state. Now here, if you talk about this aspect, the presence of conditions under which an individual can enjoy his rights, means this is a positive concept of freedom, and through the constitution, through the documents, the freedom will be given to the states to the citizens by the state. This is the concept of positive liberty, that is freedom through the state. Now, so freedom from the state and freedom through the state. So such type of statements will be there. Then there can be another statement from in the examination. That is also to check your basic understanding. Law and liberty are not opposed to each other and law is an essential condition of liberty. It means if there is no law, there is no liberty. These questions are not the questions of jurisprudence, but such questions basically are based on our general understanding of the things, whether we have understood the things or not. We need to correlate the things in the examination. So, from liberty, such questions can be asked. This is the easiest question, and the statements will be there to check your understanding. Then the preamble talks about equality of a status, and of opportunity. Then fraternity, it is the concept of universal brotherhood. That is the concept of Vasudhaiva Kutumbakam. Why I have written it in Hindi is that in the examination basically the question may be there on fraternity, that what this fraternity symbolizes. It is the concept of universal brotherhood because it was a key word in the we can say the logo that you may have seen for the G20 summits. That is why fraternity becomes important from the examination point of view. That is, we all are the sons and daughters of the same soil. That is universal brotherhood. So, from the preamble, such questions can be expected in the examination this year. Then, coming to the part 1 of the Constitution, you see, from part 1, the article number 1 was in the news. Why article 1 was in the news? India, that is Bharat, shall be a union of states. Shall be a union of states. Now, when we say it shall be a union of states, now what does this mean? Here two things. This year, last year, when the G20 summit had taken place in India, there was much hue and cry with respect to this word Bharat, because the word Bharat was used. during the summit for India. Then discussion had started that whether the government is planning to change the constitution as such, but here you see that it was not unconstitutional. The constitution recognizes Bharat also as the name of India. So either you can term it as India or you can term it as Bharat. Now this term shall be a union of states. So here also the question can be, the Constitution of India describes India as, the answer will be union of states. The word federal, federation, quasi-federal has not been used in the Constitution. The word that has been used is union of states. But if the question is, which of one of the following best defines the concept of federalism or the nature of Indian state, the answer will be quasi-federal, because we are having a quasi, that is the nature of Indian state. But if the question is that which of the the Constitution of India describes India as, the answer will be union of states. Now what is the logic behind it? The objective, basically our constitution makers wanted to give the view that the Indian Union is indestructible. It is indestructible. That is why they had used the term union of states. So the statement, which of the following statement is correct? The Indian Union is indestructible. This is, we can say, signified by the term union of states, that the Indian Union is not the result of an agreement among the units or among the states. The states in India have been created according to the process which is mentioned in the Constitution, mostly according to administrative convenience, and the units have not created the Union of India, that is, let us form India. So as the units or the states have not made India, they have not created India, they have no right to secede from it. That is why I have written here that Indian Union is indestructible. So such type of questions may be there, that the Indian Union is the result of an agreement among the units. That will be a wrong statement. The Indian Union is not the result of the agreement among the units. Now coming to the next aspect. So it was in the news, that is why it may be important from the examination point of view this year. Then there is a demand for the statehood of Ladakh. So specific question may not be asked on Ladakh as such, but your understanding that how a new state is created, that can be asked in the examination. So for that you will have to understand the process for the creation of a new state, and you will have to know that. I will make a quick revision of that. So in article number 3, the process for the creation of a state has been mentioned. Here you say that how a new state is created. The question, which of the following statement is correct regarding the creation of new states? First of all, you say that the bill can be introduced in either house of the parliament. But before such a bill can be introduced in either house of the parliament, it has to be recommended by the president. It has to be recommended by the president. So, first of all, the president, then president, before recommending the bill, what he will have to do is that he will have to send the bill to the concerned legislature. For example, if West Bengal is to be divided into West Bengal and Gorkhaland, if West Bengal is to be divided into West Bengal and Gorkhaland, so no doubt the parliament is the final authority to make laws, but here the bill will be presented in the parliament, but before that the president will have to recommend. The president, before recommending the bill, will have to send the bill to the West Bengal state legislature. So the president to send the bill to the concerned legislature for views. Here it is not consent, views. Now, so president will send the bill for its views, and the state legislature will have to give the views within a specified time. Means the president will specify a time for that, within 1 month, within 15 days, within 2 months, whatever it is. Now, after the lapse of the time frame which has been given by the president to the assembly or the assembly, then it will be assumed that the state legislature has given its views. Even if they have said nothing, it will be assumed that they have given the views. And after that, the bill will be introduced in the houses of the parliament. And in the parliament, even if the bill undergoes a large change, then the bill may not be referred to West Bengal Legislative Assembly again, and the parliament will have to pass the bill by a simple majority, and after the president's assent, a new state is created. So, here you need to remember these steps, because in the examination such questions can be asked that which of the following statement is correct regarding the process for the creation of a new state. So, such a bill can be introduced in either house of the parliament, then it has to be introduced only on the recommendation of the president. But before that, the president has to send the bill to the concerned state legislature for its views to be given within a specified time. Then, after the lapse of the time frame specified by the president, it will be assumed that the state legislature has given its views, and after that the parliament will pass the bill by a simple majority, and after the president's assent, a new state is created. So, from here such questions can be asked, and not only this, you see that questions will not be asked on linguistic states now because the states have been created, and as the demand for Ladakh is going on, maybe the question can be asked from here. Now another topic from where the questions can be asked in the prelims examination, it is the citizenship. They may not ask you any question because the Citizenship Amendment Act 2019, it was passed earlier, and no doubt the rules and procedures they have been made, but you people may be very much aware about it, that is which the minorities of which of the countries they have to be given fast track citizenship. These things you people may be knowing. Now when we talk about the next topic from where the questions can be expected in the examination, it is part 3rd of the Constitution, that is fundamental rights. Now here basic things can be asked to start with. First of all, the meaning of rights can be asked. Rights are the claims of an individual on an authority. Here the key word is the claims of an individual on an authority. So claims will be your key word here. You go and you claim something. It is, these rights are not privileges. Then basically if we talk about these fundamental rights, some questions can be related to human rights also, because whenever we talk about the fundamental rights are human rights. So the definition of human rights may not be asked in the examination, but related questions will be there. Now when we analyze this concept of human rights, these are those rights which are considered essential for a dignified human existence. And basically it was on 10th December 1948 the Universal Declaration of Human Rights, it is popularly termed as UDHR, it is a standard abbreviation. So on 10th December 1948 the UDHR was adopted by the UN General Assembly, and in this UDHR the human rights of the individuals have been mentioned. The UDHR is the source of human rights in the world. It is the source of human rights in the world. Then the UDHR, it consists of a preamble and 30 articles. 30 articles. So there is a preamble of the Universal Declaration of Human Rights and we have got 30 articles. Now, the rights, the human rights which have been mentioned in the UDHR, they are not binding on the countries, but it is expected that a democratic country should incorporate as many human rights as it can in its constitution and guarantee it to the citizens and to the people. Those human rights which have been incorporated in part 3rd of the Indian Constitution, they have been termed as fundamental rights. So, the fundamental rights are human rights. What I said, the fundamental rights are human rights. Such type of statements will be asked in the examination. Then from here, another set of questions, that which parts of the Constitution of India, they contain the human rights. So the human rights have been contained in the preamble, the topic of fundamental rights, that is part 3rd of the Constitution, then part 4, that is the directive principles of state policy. So here when we say preamble, the preamble says liberty of thought, expression, belief, faith and worship, equality of status and of opportunity. These are there in the Universal Declaration of Human Rights. Then fundamental rights, so obviously we have, and then many of the directive principles of state policy, they are there as one of the human rights. So from this part also the questions can be expected in the prelims examination. Now, because these are general questions, now from the nature of the fundamental rights, the fundamental rights are enforceable or justiciable. Or justiciable. That is, one can approach the court, including the highest court of the country, that is the Supreme Court, if the fundamental rights are violated or if they are not enforced. Secondly, these are negative obligations on the part of the state. When we say negative obligations, during your preparations you may have read such type of things. It is because of the words that have been used in the fundamental rights. The state shall not discriminate, the state shall not deny. What the state shall not do? So it is negative obligation on the part of the state. And thirdly, these rights are not absolute, but restricted rights. Not absolute, but restricted rights. So, rights cannot be absolute and there has to be reasonable restrictions on them. So, here basically if we see that we have got these natures and easier questions can be expected from this aspect: enforceable, they are not absolute but they are restricted rights. Then another area from where the questions can be asked from the, in the prelims examination is the amendability of the fundamental rights, that whether the fundamental rights can be amended by the parliament or not. If the parliament has the power to amend the fundamental rights or not. Now basically, when we talk about the constitution, Article 13 clause 2 says that the state shall not take away or it shall not abridge any of the fundamental rights. To be very specific, the constitution under Article 13 clause 2 says the state shall not make any law which takes away or abridges the fundamental rights, and if any law which is made in contravention with this clause to be declared as void to the extent of such contravention. This is article number 13 clause 2. You may have read it. After that, the first amendment act, it had added article 15 clause 4 in the constitution. Along with it, it had also added article 31b and the 9th schedule in the constitution. And article 15 clause 4, it talked about special provisions to be made for the socially and educationally backward classes, including the scheduled caste and scheduled tribes. So it violated right to equality, because article 15 clause 1 says the state shall not discriminate amongst the citizens, and article 15 clause 4, it was added by the first amendment act. It authorized the state to make a special provisions. Then article 31b and the 9th schedule, you may have read it in detail in your during your preparation time. Now this first amendment act, it violated right to equality and right to property, which was a fundamental right at that point of time. And in the background of it, the cases started coming before the court that whether the parliament has the power to amend the fundamental rights or not. In the Shankari Prasad and Sajjan Singh case, the Supreme Court said yes, the Parliament has the power to amend the fundamental rights. Then, so Sagri Prasad case was different, Sajjan Singh case was different, but the judgment was the same. So in these two cases, the Supreme Court said yes. After that, in the Golaknath case, the Supreme Court said no. The Parliament has no power to amend the fundamental rights. Now, here, so this question, that in which of the cases the Supreme Court held that the fundamental rights cannot be abridged, they cannot be amended, the answer will be Golaknath case. Then after that, the 24th Amendment Act 1971 gave the power to the Parliament to amend any part of the Constitution, that the Parliament has the power. So here Article 368 was changed and the Parliament was given the power to amend any part of the Constitution. So it amended Article 368. And then after that, in the Keshwanand Bharati case, the Supreme Court gave the basic structure doctrine. And the Supreme Court held that the Parliament has the power to amend any part of the Constitution, but the basic structure is not to be disturbed. So, but the Supreme Court in that case, that is the Keshwanand Bharati case, did not elaborate that what constitutes the basic structures of the Constitution. But from time to time, the Supreme Court had held that the aspects like sovereignty of India, then the ideal of a welfare state, federalism, secularism, judicial review, rule of law, the balance between the fundamental rights and directive principles, then democratic and republican and a parliamentary form of government, supremacy of the parliament, independence of judiciary, all these aspects, they contain the basic structure of the Constitution. These things you may have already read because you are in the last leg of your preparation. So, the Keshwanand Bharati case, the Parliament has the power to amend any part of the Constitution, but the basic structure is not to be disturbed. And here the statements will be, the basic structure is, answer will be, it is a judicial innovation. And then after that, it is the Supreme Court which has to decide that what are the basic structures of the Constitution. So, these are the aspects that in the preliminary examination that can be expected from these aspects. The important fundamental rights which can be there in the examination, like article number 14, 19, 21. These articles in brief according to the needs of the examination we will be discussing in the next session. We will stop here for the day.